The Ledbetter Act stems from the case which dealt with an employee at the Goodyear Tire and Rubber Company, and her name was Lily Ledbetter. Miss Ledbetter had been an employee at Goodyear for approximately 19 years when she retired. At that particular point, throughout her career or tenure at Goodyear, she had consistently received low rankings in her annual performance and salary reviews, and therefore her raises were low. So after she retired, she sued Goodyear for gender discrimination and a violation of Title VII of the Civil Rights Act, alleging that the company had given her low salary because of her gender. In the lower court, the jury found for Miss Ledbetter and awarded her over $3.5 million, which the judge later reduced to $360,000. Okay, if you remember from the Title VII audio lesson, damages under Title VII are capped for $300,000. So the other $60,000 came from some other fees that she was awarded, but overall the compensatory damages and back pay was reduced to $300,000. Now, because Goodyear lost, they then appealed. They cited that the Title VII provision, which requires discrimination complaints to be made within 180 days. So if she knew, what Goodyear was saying is that if she knew all along that she was receiving this particular discriminatory pay, then she should have filed suit because Title VII has a 180-day cap. At that particular point, let me show you in my notes. This is what the jury awarded her, and at that particular point, they reduced it. Now, in the post-trial motions, they found that the males from Goodyear were receiving this particular amount in salary, and this is what Miss Lily Ledbetter was receiving, and that amounted to a $14,304 difference. And in her lawsuit, she outlined exactly what an individual could do with $14,000. Now, this case then went to the Supreme Court. That is, it is known as the Ledbetter versus Goodyear Tire and Rubber Company. It was, the citation is 550 U.S. 618, and it was decided in 2007. At that time, Justice Alito, who was joined by Justice Roberts, Scalia, Kennedy, and Thomas, ruled that Ledbetter's case or her claim was too late. According to them, this is what the Supreme Court said. Pay claims involve discrete acts, not violations, said the court, and they were interpreting a previous precedent case, which was the Morgan case. The court concluded that the paychecks that Ledbetter continued to receive from her employer were mere effects of her employer's earlier discriminatory decisions and did not reset the 180-day filing period. So therefore, the court in the 2007 case said, Lily Ledbetter, although you've been receiving discriminatory pay for years and years, we are going to look at the first paycheck that you received that was discriminatory, which may have been over 19 years ago. And because you didn't say anything then, you cannot bring the suit now. Okay? So a discriminatory act which is not made the basis for a timely charge is merely an unfortunate event in history which has no present legal consequence, is what the court said. So at that particular point, Lily Ledbetter was out. So she won millions of dollars in the circuit court. The appellate court reduced her judgment to $360,000, and then she gets to the Supreme Court and loses. So that is why we now have the Lily Ledbetter. It's called the Ledbetter Act of 2009, and it stems from that Ledbetter case. So President Obama signed it, and the act restored the protection against pay discrimination, which was stripped away by the Supreme Court's decision. The act made clear that each discriminatory paycheck, not just an employer's original decision to engage in pay discrimination, resets the period of time during which a worker may file a pay discrimination claim. So what that means is that if the discrimination started 19 years ago, the clock begins to toll every time she receives a paycheck. So while she may not be able to go back to 19 years ago, and again, I'm using that as an example, she can go back to the time frame within 180 days and allow her to at least collect something. So you're not going to be stripped of all protection or all rights to receive back pay. and to get your compensation. But the court said initially, in the Supreme Court decision, said she couldn't do anything. There was no recourse. It was an unfortunate event in history. However, the Ledbetter Act of 2009, like I said, restored protection. It reversed the Supreme Court's decision, and it allows for an individual who feels as though that they have been subject to pay discrimination to file suit, and each paycheck then tolls the 180-day clock.